thing that I'm sure you find, and the judge mentioned this too. Apparently, and confirm this for me, is it true that the drunk driving law or driving while under influence, DUI, in Ohio is a law that is oftentimes, I don't want to say tinkered with because that's not very professional, but adjusted by the legislature?
Oh, it's constantly adjusted, and it really is constantly adjusted. There's nuances that come out continuously over and over in DUI law. When I first started in evaluating DUIs, the law in Ohio was if the legal limit was a .10.
Yeah, it's changed.
And now it's a .08 in terms of taking a breath test. Now they have, if you've received 5 DUIs or if you're charged with 5 DUIs in 20 years, that becomes a felony.
I see.
It's a greater look-back period that they didn't have before.
And these are actual, when we talk about the law, Kris, there's, of course, case law, judge-made law, that there's nothing necessarily on a book, but that's the way the judge decided in a particular district, ours being the 9th, and it's good law. You have an argument. But what you're talking about is actually the verbiage of the statute, right?
Absolutely.
So our lawmakers are literally changing it. Well, of course,
our lawmakers do continuously change, and I think some of it has to do with, well, a lot of it has to do with some of the repeat offenders that just repeat continuously over and over.
Yeah.
I think one of the big changes a few years back is that if they were looking to force someone that's had, I believe, 4 or more prior DUIs, they were required to give a test, to take the breath test, to take a blood test, some sort of chemical test. That's not required of someone that's never been stopped before.
I see. When the lawmakers pass a bill, which is signed by our governor, that maybe, to the ordinary viewer looks, well, yeah, you changed 3 words in a big deal. But doesn't that bring about a whole new body of case law with it when judges have to decide on that?
Yes, absolutely. When there's been a change in the law, and
even if it be a minor change.
It could be a minor change, and at that point, it's reading the statute and seeing how it applies in a certain situation that may be different from the way they were reading it before. So a judge now has to take a look and see how they're going to decide on that, and if whether it's the prosecution or the defense that doesn't like the way the judge has decided,
take it up on appeal.
They could take it up on appeal to the next level, in this case the 9th district, and then ultimately potentially to the Ohio Supreme Court for them to decide on some of these nuances in the law. Absolutely.
Yeah, we had Claire Dickinson on the show. He sits on the 9th district, and he talked extensively about, as did Judge McElvain, the changes of that law are causing more and more in the appellant process. And I guess not to take away from our brother attorneys who were practicing way back when, like my Uncle Tony or whatever, but it is a challenge to a younger person like yourself who's just getting into it, whether you're defending people, but you're also watching this law change all the time as well. So, well, I guess that leads this is a perfect segue into the next question. So the number one question, I'm taking on myself to call it the number one question, but you might agree with this. The number one question that everybody wants to know when they're stopped for DUI is whether to take the breathalyzer or not. Well, what do you say, Counselor?
I say that's the number one question.
We agree on that part.
Absolutely.
Okay, now what about take it or not take?
With friends or in a family, and they certainly ask that question. That question has gotten much more difficult over the years. I think from a defense attorney's perspective, years ago, as a defense attorney, you always want from your client, you want as little evidence as possible against your client in terms of in terms of whether it's going to lead to a conviction. As a defense attorney, you don't have to prove anything. It's
You're
the state
innocent
that
till you're proven guilty. Yeah.
That's correct, and the state has to prove your client guilty beyond a reasonable doubt.
Okay, so why isn't it broad brush? Why don't we just tell everybody don't take it then?
Well, because of the changes in the law and the constant changes from the legislation, it makes it more difficult now to be able to decide whether someone should be taking a breath test or not. If, for instance, if you've had a prior DUI,
Yeah.
and you're stopped for a subsequent DUI, and you tell that client from now on, you should never take the breath test, you could, because you've refused in the past, because you have a prior DUI, and if you refuse to take a breath test the second time around, that's actually a violation of the law.
I see.
And as an attorney, you'd be advising them to
break the law.
I
see.
Which right now, I think is an unsettled ethical question
Sure.
for attorneys, is to how do you advise your clients in what they should or shouldn't do. So it's not just an easy question anymore, where you would hear in the past, you should never take the breath test.
No broad brush on this one.
That's definitive evidence. Once they have that, it's very easy for them to prove a DUI. In this case now, there's so many more different types of penalties, and several years back they changed it where if you refuse to take a test, there's increased penalties. Even on your first offense, if you refuse to take a breath test, you face additional penalties. The mandatory minimum for a first offense is 3 days in jail,
right,
or a approved driver intervention program. If you refuse to take the test, that increases the penalty by an additional 3 days in jail.
Oh.
And over the years, they continuously tweak the
that's a good word. Tweak.
The Ohio DUI law, and just as I was saying before, now if someone doesn't take the test, they have a prior DUI, that's a violation of the law in itself. So whether to take the test or not is a very difficult question for really a defense attorney to answer for the clients. Again, I would just end with, as a defense attorney, we always like to have as little evidence as possible against our clients.
Makes sense. But one thing, we're coming to a close here now, but I'd love to talk to you about this some more, is that it sounds to me like this is nothing for the layperson to be fooling around with. I mean, the need for a lawyer is abundantly clear. Is that a clear message we should be sending our viewers?
Yes, I would say so. And I have had some people say, well, there's no way to really fight this. Do I really need an attorney? Well, there's so many different things to consider, as we were talking earlier. How do you get your license back? If you're doing a driver intervention program, what should you expect if you're going to a driver intervention program?
Yeah.
If you're on probation with the court, what are you supposed to expect with probation? What's the process? How do I get my car back?
Yeah.
So clearly it's very complex.
It is very complicated. Well, Kris, I'd like to thank you for being our guest on Law Talk. To view this episode and others, go to www.czclep.org. I am John Celebrezze, and I thank you for tuning in to Law Talk.
To keep up on Medina County and other legal issues, go to www.czcourtreporter.com, a function of the Celebrezze-Zangi Community Legal Education Project. At CZ-CLEP, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ-CLEP is dedicated to the educational venues aimed at enhancing the understanding by all citizens. For a complete listing of dates and times for this telecast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV.
I'm John Celebrezze. Please join me in getting a better understanding of the law.